Well, thank you so much for the opportunity to speak here today. I'm very honored. As you already pointed out, I'm running my doctoral thesis on the constitutional limits of law, of the use of AI in court proceedings, and I focus on civil proceedings. My dissertation is intended to contribute to the identification of the key constitutional challenges arising from the use of AI by courts, and to also trace the limits of the capacity of constitutional law. And I'm using Austria as an example, but I also hope that it is transferable to other legal orders that are based on the rule of law. I hope it switched to the next slide. I think it did. The starting point of my dissertation is the more general observation that obviously technical developments in all conceivable forms and intensities have massively changed and shaped our society, especially in the last century, but that the process at a technical level is by no means at its limit. Especially with regard to digitization and automation, there are many things happening with AI and particularly machine learning at the center of it. Society as a whole, I think, has on the one side high hopes for AI to improve our lives in many fields and many ways, but at the same time, I feel like there's a lot of skepticism. With regard to the legal sector, it has not been that profession that has been primarily associated with the use of new technologies. However, especially with regard to the potential of AI and machine learning, the question, at least considering partial substantiality of lawyers with AI, is now being more and more discussed. However, the questions mostly, at least in Austria, focus on the factual implications of those technologies, like job loss or how to finance them, or the technical possibilities and limits. And in-depth legal analysis from the constitutional perspective in Austria has not been conducted, and I want to close that gap because I think it's very important. The doctoral thesis pursues several aims. From a technical point of view, the current state of research in the field of AI and particularly machine learning shall be outlined. The focus for me lies, as I said, on self-learning AI and therefore on machine learning. Then this elusive technological phenomenon shall be concretized by defining individual fields of application as the basis of the constitutional analysis. And I intend to show the strength, but also the weaknesses of such technologies in court proceedings. And due to these weaknesses, I think the usage is already limited from a rather technical perspective before we even get to the constitutional analysis as such. The overall objective of this part is to counteract exaggerated expectations as well as unrealistic fears, which are very often articulated. The legal analysis of the doctoral thesis is intended to provide a more detailed assessment of the current constitutional framework with regards to the use of AI in civil court proceedings. In order to achieve that goal, it is necessary to identify the essence of the potentially affected constitutional provisions and to question the extent to which they are capable of capturing the current technical phenomena. In the case I find gaps, I will then try to determine whether and in which direction an adaptation is required. It should also be noted at this point that I do not pursue an all or nothing approach, and therefore I don't aim at qualifying AI as either entirely permissible or impermissible. This would be not reasonable, especially against the backdrop of the diverse fields of application of AI and the differentiated constitutional regime we have. Now to the structure of my doctoral thesis. Since the constitutional and procedural questions that are raised in this thesis are linked to the development of technical nature, the technical foundations must also be addressed, even though I'm a lawyer, but I try to do my best here. This interdisciplinary approach is also reflected in the structure of the thesis. Apart from the introduction, obviously, and the conclusion, the thesis can roughly be divided into two main sections, namely a technical one, chapter 1 and 2, and a legal one, chapter 4 to 6. And these two sections are connected by chapter 3, which concerns the possible fields of application of AI in court proceedings, so a more use case approach. To get into the first chapter, the technical foundations, it should be again divided into three the technical section as a whole should be divided into 3 chapters, and the first one is called like technical foundations, and I try to roughly outline the concepts that are often discussed right now concerning AI as well as legal technology in general. I will then try to point out that I will follow a comparatively narrow understanding, which is sort of the same as machine learning. And then since AI and machine learning can be examined in its entirety, I try to specify use cases of machine learning in court proceedings that I would like to focus on. In the second section, a comparison should be made between human and machine decision making. In doing so, both humans and AI systems are classified in terms of machine theory, and the main differences between them shall be illustrated. The current state of AI research, so-called weak AI, and also the comparison of humans and machines against the background of the 4 forms of intelligence, according to Walster, serve as a starting point. It shall be shown that humans and AI systems do have parallels in decision-making at first glance, which are primarily the characteristics of adaptivity and non-triviality. However, if one takes a closer look at the decision-making process, it becomes relatively clear that differences very well exist in the factual. As mentioned, the third chapter serves as sort of a transition from the technical foundations of the thesis to the legal analysis. The focus of this chapter is on certain AI systems potentially used in court proceedings and their technical characteristics identified on the basis of civil procedural regulation. The AI use cases and their technical features shall be elaborated on the basis of selected stages of the civil proceedings and the respective tasks that have to be performed by the judge. First, the topic of taking evidence in the context of the oral proceedings is examined in detail as a procedural stage in which the judge interacts with people and objects that are involved in or at least relevant to the proceeding. The question of how the judge has to proceed and which of their skills are particularly called upon depends to a large extent on the type of evidence that is involved, since the taking of evidence is characterized by the interplay between evidence topic and evidence types. Following the taking of evidence, the judge must evaluate the evidence and then also determine the facts. This stage of the proceeding is sort of an example of a part of the judicial decision-making process that takes place only in the judge's mind and only becomes apparent to the outside world when the judgment is rendered. In the course of evaluating evidence and determining the facts, the judge has to cope with a rather large number of necessary decision-making processes of various kinds, for which, however, the law provides him or her relatively few points of references. In many cases, there's only a more general reference to the principle of free evaluation of evidence. The skills to be demonstrated by a judge in dealing with this kind of stage of the proceedings are thus less tangible than those necessary for the taking of evidence. In essence, it is a matter of systematizing, evaluating, and interpreting the information gathered in the course of the taking of evidence, and this requires the judge to have some sort of capacity to comprehend human communication, including the understanding of the perceived acoustic, but also visual signals, for example, nonverbal communication as shown in the face of witnesses. The third area of judicial activity where AI could be used is the field of legal assessment based on the established facts. Again, this is a stage of decision-making that does only take place within the judge's mind. However, the process of legal assessment requires a separate consideration because it's not a logical, empirical one, but a rather normative, dogmatic task. After theoretical positioning, the steps the judge has to take in order to arrive at the legal assessment of established facts are to be determined. From this, in turn, the capabilities of the judge can be derived, which in the case of recourse to AI applications would also have to be fulfilled by AI. Essentially, this involves knowledge and understanding of the entire applicable law, as well as the ability also to interpret the law as a prerequisite for subsuming the established facts. The determination of the potential forms of AI suitable to support or supplement a judge in the course of civil proceedings is followed by a legal analysis, constitutional law analysis, and the central question is whether and to what extent constitutional norms are affected by the use of such AI technologies. The constitutional implications can essentially be divided into three categories and will therefore also be dealt with in 3 chapters. The first category comprises the constitutional provisions that address the judge as such and also their characteristics. This refers to the constitutional enshrined judicial guarantees, in particular judicial independence, and the skills that can be derived from that. Together, they form the concept of the judge of constitutional law. In the search for the core content of this constitutional concept, it is necessary to first answer the question whether the Constitution assumes the existence of a judge. If this is the case, which in case of Austria it is, the next step is to analyze whether such an assumption can be equated with the obligation to restrict the function of the judge to a human, or whether an AI system could be appointed as a judge. This question, and I want to point that out specifically because this is often confused in literature, I feel like, is detached from the question of whether AI meets the constitutional requirements for the judge apart from being a human being. Therefore, the goal of this first subchapter is to find out whether the human being serving as a judge as such has an intrinsic value under the constitutional law. Next, it is now necessary to examine what kind of skills a judge has to have in order to meet the constitutional requirements. When identifying these skills, the tasks of a judge when identifying these skills, the task of a civil judge needs to be fulfilled, and therefore that serves as the starting point or the point of reference. Thus, the first step is to examine what skills constitutional law requires the judge to have in the course of taking of evidence and establishing facts. The second step is to ask what requirements the Constitution places on the judge as a lawyer, and in addition, the requirements concerning the personality of the judge on the one side and the question of the internal decision-making process on the other side needs to be addressed. Finally, based on the requirements that have been identified for judges from a constitutional perspective, it must be examined which of these abilities or characteristics could be fulfilled by AI systems, at least to the same extent as it is done by humans. If, against the backdrop of the technical state of the art of AI, it is concluded that certain features of the constitutional concept can currently only be fulfilled by a human being, appointing an AI system to become a judge is ruled out. The support of AI systems, which is not per se inadmissible as a result, must subsequently then be measured particularly against the standards of judicial independence. And this ultimately results in a differentiated picture, which of the AI applications I tried to identify in chapter 3 are compatible with the constitutional concept of the judge and which are not. The second constitutional category against which the use of AI in the course of civil proceedings is to be measured relates to provisions that are specifically tailored to court proceedings and thus constitute procedural guarantees. In contrast to the previous chapter, the perspective is not that of the judge, but of the person subject to the law as a party to civil proceedings. As a result, the central constitutional provision is not judicial independence, as is laid down in Article 87 of the Austrian Constitution, but rather the right to a fair trial enshrined in Article 6 of the European Charter of Human Rights, which is in Austria constitutional law. The question to be answered in this chapter, the questions are similar in structure to those of the previous one. Therefore, it must first be examined what kind of concept underlies Article 6 ECHR and whether the human nature of the judge as such is mandatory to ensure a fair trial in the sense of the convention. The next step is to consider which of the AI applications identified in chapter 3 are potentially in conflict with the components of Article 6. In detail, this involves publicity, orality, immediacy, independency, again, and impartiality. A special component in this context is the question of the infringement of the right to the lawful judge, as this is laid down in Austria, not just in Article 6, but also in Article 83, paragraph 2 of our federal constitution. And then finally, this chapter will address the issue of access to justice, since the aim of AI and particularly legal technologies is to improve this access to justice, which can be derived also from Article 6. Furthermore, the use of AI in the course of civil proceedings could also be in conflict with constitutional provisions that do not necessarily define court proceedings as a prerequisite for application. This is primarily the principle of equity and the components derived from it, as well as the right to respect the privacy. Related to this is the prohibition of the degrading of the use of human being as a mere means to an end, which can be derived primarily from Article 3 of the European Convention of Human Rights, and is also very closely connected to the principle of human dignity, as it is laid down in the Article 1 of the Fundamental Rights Charter of the European Union. This complex of issues will be examined as the third category of the constitutional analysis, complementing the two other chapters that I just tried to describe. Finally, to conclude, obviously a summary of the findings will be given. Furthermore, in case I detect any kind of gaps, I try to make propositions, de lege ferenda, if and in what way the constitutional framework should be amended. Thank you very much for the attention, and I'm very much looking forward to your questions and also discussion. Thank you.
Thank you so much, Elisabeth. The first question is, you state that humans and AI-based systems show parallels in decision-making, which are primarily the characteristics of adaptivity and non-triviality. But you say that there are differences as well in the factual. Can you give an example on this difference and why they are important for the constitutional assessment?
Sure, thank you very much. I think one of the main limitations and therefore differences right now is in the field of emotional intelligence and social intelligence. These are fields where AI or machine learning is performing very poorly right now. And these are qualities that a judge obviously also has to have in order to assess, for example, a witness and tell whether this person is telling the truth or not. Machine learning or AI also has a very hard time understanding the big concepts as we humans do. Yeah, and then obviously we do learn a bit differently. We do think a bit differently. For example, a human is much more aware of the whole decision-making process from his or her own perspective. Therefore, it can try to trick us by giving reasons that were actually not the reasons for deciding, which is something an AI system can't do unless you train it to lie, and then that's like the goal, but it's not aware that it's lying. So that's maybe a few examples to show that.
Thank you so much. I have a second question, more centered in access to justice. If I'm not wrong, you state in your presentation that AI could help access to justice. But considering the existence of inequality among different types of litigants, such as big law firms and companies on one hand, and individuals and vulnerable groups on the other, who tends to have more advantage by the incorporation of AI system to civil proceedings? In other words, these technologies tend to amplify the inequalities in civil proceedings, do you think?
Very interesting question. I'm honestly not entirely sure. I think it would depend on the kind of technology. Of course, especially big law firms with a lot of money can afford the greatest technologies and therefore become even more powerful. The same holds true for big companies in general, regardless of the access to justice or governments. But I do think that it might also help those that would not have the means normally to go to court when it comes to I think, for example, the flight right platform that helps you to get your money if your airplane was delayed, for example, something like that, like those small things where like normal people, I want to say, or people that like don't have enough money or whatever would never go to court to, and that might help them. So I think it really depends on the kind of technology that you focus on.
Okay, thank you so much. Mihail has a quite statement. Is it possible to answer all these questions in one thesis? He states, maybe it would be advisable to narrow down the scope to the issue of formal versus procedural fairness. Evidence-based reason is an enormous topic. I don't know if you want to make some comments on that.
Okay, sorry. Yeah, I thought you meant him. Thank you for this. It is indeed something that is well. I have a lot of questions to answer in this thesis. That is quite clear, I think. I mean, I'm not entirely sure what you mean by formal procedural fairness and evidence-based reasoning. I have to reduce myself to the dogmatic perspective. So I try to only answer these questions from the perspective of constitutional law. I don't answer them from a legal theory perspective. I also don't answer them from a psychological perspective, from a philosophical perspective, from a sociology perspective, and all of that. So I really concentrate just on constitutional law, and therefore I think it is manageable. And I also try to maybe give some more general ideas and sort of points where I think we're standing right now. And then other scholars can focus maybe on a tinier bit of that and do a more detailed analysis. Yeah, so, but I'm not sure if I understood your question correctly or your concern.
So could I have just a small follow-up? So evidence-based reasoning is the reasoning related to the assessment of evidence, and we have a lot of different approaches in AI and law in this connection, starting with classical rule-based or argumentative approach, through story-based approach, Bayesian approaches, and finally the application of machine learning algorithms. And each of these systems raised quite different questions in connection with the assessment of evidence. So this is, of course, just a point in the discussion because it may be possible to rightly address all these questions within one thesis. But I think that it raises the threshold of difficulty because you actually need to investigate many different approaches and also the tools that may be used in connection with evidence related part of civil proceedings. Formal or procedural fairness refers to such issues like the equality of parties or formal warranties in the course of legal procedures, the assessment of the formal part of the lawsuits and other documents, and so on and so forth. But of course, it's up to you and your supervisor to determine the scope of this research. Thank you.
Thank you very much. Yeah, I definitely a valid point. I try to not have this danger of addressing too many things. I try to address it by picking use cases. So, for example, when it comes to evaluating evidence or taking evidence, I want to look at a very specific mimic recognition system, for example, or a system that analyzes the speaking. And so I have for each section that I just try to explain, I have 2 to 3 use cases. And then I want to look into them and how they work. And compare to how the human does it, and then see what is what from the constitutional perspective. So I might not that's also why I tried to say it would be almost impossible to say I look at machine learning in general and see, because there are just so many, from a technical perspective, so many different options. That's why I try to pick out use cases, and I hope that by doing them I can sort of come to more general conclusions that can be a great starting point to then do an analysis on other specific technologies that might be used at some stage in the proceeding. Thank you.
Okay, thank you so much, everyone. Thank you